We want to continue to follow breaking news now out of Greenville County, where a judge has just ruled that the teenager charged in the deadly shooting at Tanglewood Middle School, this was back in March 31st of 2022, he was 12 years old at the time, will be tried as an adult. Solicitor Walt Wilkins, 13th Circuit Solicitor, giving remarks now. Let's take a listen.
Jordan up to General Sessions Court, and she ruled in the state's favor. So he has now been waived up to General Sessions and will be treated as an adult for the charge of murder in this particular case.
You've already able to release the minors there at this time?
Yes, because he is now considered an adult in General Sessions Court. So that is the jurisdiction in which he's being prosecuted now.
The judge talked about how difficult this decision was. What do you think that says about this case?
This is a case where there are no winners. It's an extremely difficult case. As the judge said, one of the most difficult cases she has seen, as well as myself. As the solicitor, we're tasked with protecting our schools and our communities. And when a young mind commits a horrific crime, it makes it very difficult for everybody. But we have to follow the law. We have to follow our procedures in a way that gets us to a just result. The juvenile system in this particular case, based on the crime, the premeditation, the horrific incident, shooting in cold blood, along with a very young mind, presents a difficult situation. But it's one in which the Department of Juvenile Justice is not equipped to handle. And I think that weighed heavily in her factors, and the Kent factors, so that we can now have this case in General Sessions, and we're going to start working towards a just and fair resolution for the defendant. And that's one of the tasks and the obligations of the Solicitor's Office.
Do you believe that your office is going to pursue the charges as they currently are, reduce them, or try to get a plea deal?
Certainly. So we will present this case to a grand jury for the charge of murder. And if they come back with a murder indictment, that's what we will go forward with. However, it is the Solicitor's Office discretion to formulate a sentence using other charges that are available based in our discretion. So we do have the discretion to engage in plea discussions or negotiations based on a lot of factors that may come to us to find a good resolution. We're going to talk with the family and get their input. We're going to talk with the school as well to determine the effect that it had on our school community. We're going to talk with law enforcement. And then, of course, we're going to hear from defense lawyers as well, and we're going to hear their mitigation as well, because it is such a sad day where we have a 12-year-old who's no longer with us, and we have a 12-year-old that's looking at being incarcerated for a significant portion of his life. So he has lost his childhood based on his actions. And so it's just a very sad, hard situation for everybody to determine. But we're also tasked with making sure that our communities are safe, and that our schools are safe, and that everybody has the right to send their children to school and know that they're going to come home that day. So we have a lot of competing interests, and I feel confident that we will end up in the right place for this community and for this family.
Do you have an idea of a timeline of when these next steps will take place?
Sure, it'll be relatively soon. So this case is already 2 years old, or almost 2 years old, and so we will be indicting in May, and during that time we will begin our deliberations and negotiations with defense counsel and hearing from all relevant parties. And so my goal is to have something hopefully negotiated out by the end of the summer. And if not, of course, then we always have the option for a jury trial.
Of course. And you said previously that the youngest person the 13th Circuit has ever prosecuted or tried as an adult was 13 years old. Is this now the youngest person your office has tried based on when the crime?
I'm going to have to check that. Miguel Cano might have been 12 years old. He was in 7th grade as well, the same as this student. I'm not sure if he had turned 13 yet. He may have. If so, they were within months of each other. So it may be the youngest one so far by a couple of months. I'm not exactly sure. I've checked birth dates. But regardless of that, it is shocking to the conscience to think that a 12-year-old could have the premeditation and the ability to carry out these particular crimes. And so that is something that we as a society need to take a deep, long look into as well. And so it's just a difficult situation, as well as we're seeing an uprise in juvenile crime and juvenile violent crime. There is literally a wave of juvenile crime occurring in Greenville County right now that is 2 to 3 times more than last year and 3 to 4 more times more than the year before than that. The number of waiver hearings that we have pending right now is 10. We had 11 until today. Now we have 10 waiver hearings of juveniles who've committed violent crime. So this is not the only case that we're dealing with in family court or we're going to be dealing with in general sessions. And so we are having a much bigger conversation with ourselves about why are juveniles committing more crimes? What can we do as law enforcement, as prosecutors, as a community, as a society to reduce this? And it should be a priority of this community to reduce the amount of violent crime that we're seeing in juveniles today.
With the charges that he's facing, what are some of the potential sentencing that he could receive if found guilty?
So the charge of murder carries 30 years to life, and it is day for day. Now, he is a young mind, a young person, 12, now 14 years old, and so he could not receive a life sentence. He is too young for that by law, but he could receive a very substantial sentence under the murder statute, and it's day for day, meaning if you're sentenced to murder and you get 30 years, you spend exactly 30 years in jail. The next lower down that will be presented to us by their defense team, I'm certain, is voluntary manslaughter. It carries 1 to 30 years. And if you're sentenced to a time of incarceration for voluntary manslaughter, you have to serve a minimum of 85% of that particular sentence. The other 15 is based on how well you behave inside the Department of Corrections.
Would this juvenile be given credit to the time he's already served as a juvenile, should he be convicted?
Yes. So his time of credit will occur the day that he entered the Department of Juvenile Justice. So if he has 2 years inside the Department of Juvenile Justice, he'll stay there until he's the age of 17, and then he'll go to a part of the jail that has just 17-year-olds. And then upon turning 18, he will then go inside the Department of Corrections normal jail population.
Do you want to say anything to the family, both for the juvenile's family and the victim's family?
You know, it's one of the most difficult cases, I think, that we've ever had to deal with. And as I said, I don't want to believe that a 12-year-old can commit this heinous crime, but it is our obligation, and it's my oath and my duty to protect the members of this county. And we will continue to do so, but we will do it correctly, transparently, in the utmost fairness that we possibly can. And we want to give justice and some solace to this family that lost their loved one. But that's all it is a little bit of solace, because they will never have their child back. And we will try to give some hope to the family of this defendant that he can maybe one day be rehabilitated, and that he will one day come home and maybe be a productive member of society with plenty of life to live, as he is such a young defendant, that he will ultimately come home someday and hopefully be a good member of this community. And take advantage of the services that he will have available to him in the Department of Corrections. He can get a GED, he can get a college degree, he can learn a very specific trade. There are many services for him that he can take advantage of if he so chooses, that he could try to right this wrong and make it his lifelong work to right this wrong and try to give back to this community one day.
Does it worry you that the judge said that the detention center was hard to live in? Does it worry you about his chance of rehabilitation?
You know, I'm not the director of Department of Juvenile Justice. I know that it's probably an unhappy place to house large amounts of juveniles in one particular facility, or numerous facilities. I think they have 3 or 4 around the state, depending on where you're designated. But I know that once he is, the juvenile justice does have, once he is sentenced, he will have the availability for services. And I do know specifically that once he is 18, in the Department of Corrections, he has numerous services available to him.
given the fact that the Greenville County Detention Facility for Juveniles may close, has that influenced or kind of informed your office's policy on how you bring charges on juveniles?
No, it really doesn't, because we really have to follow the law, and we have to follow the facts, and we have to do our job. It has created a issue of transportation, because they have to be transported to Columbia and back. It has affected those juveniles who might be incarcerated inside Greenville County for a day for a minor crime, which now they're just given a ticket because transportation is too burdensome on law enforcement. But in cases like this, it's a shame that they can't be housed in Greenville County, closer to family, more visitation. I think it's a better situation for the child. But those are issues beyond my pay grade and beyond my capabilities and abilities as the solicitor. However, it will be a good day when the juvenile facility is reopened, because I think it is a benefit to this community, and it does help us with the rehabilitation side of our juveniles who decide to get into trouble.
If the defendant were to watch this in 30 years after maybe he's released, do you want to give him a message about maybe why this happened, or do you want to give him a message of maybe hope?
You know, as I said before, I just hope that he can use what time he has now to become a better person and give back to his community one day. He engaged in a horrific crime as a young mind, and it is unfortunate that he landed himself in this situation.
Do we have the defendant's name?
I'm sorry?
Do we have the defendant's name?
Yeah, his name is Jordan Williams.
How do you spell that?
Jordan Williams, Williams.
The solicitor there talking about the current situation. The young man will be tried as an adult in this case. The solicitor saying, after talking with family, the school, and law enforcement, that the solicitor's office will decide how to move forward in this case. Obviously, when we're talking about children
who are dead.
Yeah,
Yeah.
It's such a tragedy, but so much attention is going to be brought to this case.
Yes, and the solicitor saying that there are no winners. One 12-year-old is dead. A 14-year-old has now effectively lost his childhood, and he did name them. This suspect has not been named before because he was in the juvenile system, but now that he will be going and tried in general sessions, his name is Jordan Williams. Jordan was 12 when he allegedly committed this crime. He's now 14 years old. And it also sounded like Solicitor Wilkins was kind of giving the defense an opportunity to negotiate. He said that they will look at school, facility, law enforcement. He'll talk to defense. And then he actually mentioned that he could be tried not as murder, but as voluntary manslaughter, which would cover a much smaller sentence. And it sounds like they're hoping to negotiate that, have that agreed upon by the end of summer. And then he said, if that doesn't happen, then we'll have a jury trial. So it sounds like he really is opening up the door to the defense to have a to plead down a little bit.